welcome to the firm. On the show this week, the Madras Bar Association launches a fresh salvo against the creation of a National Company Law Tribunal. In August 2000, the Justice Iradi Committee was the first to recommend the creation of a National Company Law Tribunal, or NCLT, and Appellate Tribunal, NCLAT, that would subsume the Company Law Board, BIFR, and winding up cases in high courts. The rationale? To avoid long-drawn court proceedings. But the Madras Bar Association thought this tribunalization to be outside the legislative competence of Parliament and violative of the doctrine of separation of powers and independence of the judiciary. That case, referred to as the R. Gandhi case, was decided in 2010 when a 5-judge constitutional bench upheld the Parliament's right to create such a tribunal, but observed several unconstitutional design defects and hence laid down guidelines on the composition and functioning of NCLT and NCLAT. Fast forward to today and the Companies Act 2013 that makes the NCLT and the NCLAT a legislative reality. But those opposed to the tribunalization of the judiciary are yet to be convinced, and their argument has been bolstered by the sorry state of affairs in existing tribunals across the country. So it should come as no surprise that the Madras Bar Association, who half lost that case in 2010, is agitating again. It has filed a petition in the Supreme Court against the Companies Act 2013 design of the National Company Law Tribunal and Appellate Tribunal. To discuss this petition, I am joined by Arvind Datar, a senior advocate or counsel of the Supreme Court. Mr. Datar will be arguing that matter on behalf of the Madras Bar Association. And I have with me in Mumbai Bharat Vasani of the Tata Group. The Tata Group companies, as you know, deal with company law matters on an hourly basis. Well, gentlemen, to both of you, a very warm welcome. Mr. Datar, in your petition, you've laid out certain design deviations, when it comes to the NCLT and the NCLAT versus what was laid down in the R. Gandhi case. For instance, the Supreme Court had said in 2010 that persons below the rank of a secretary or additional secretary should not be appointed as a member of the NCLT. Despite that, this Companies Act allows for it. Then you've said that the selection committee must consist of 4 members, with the Chief Justice of India having a casting vote. That's what the Supreme Court said in 2010. Instead, in the Companies Act, the selection committee is 5 and the primacy of the judiciary has been reduced. My question to you is this. Do you contend that this is a conscious deviation from what was laid down by the Supreme Court in 2010? Or, if this is fixed, will you continue to agitate this matter in the Supreme Court, or will you be fine with what we have?
Well, I think that it is unfortunate that despite the Supreme Court clearly laid down certain guidelines, the Companies Act 2013 has deliberately sought to not conform with these guidelines. And it is our consistent stand of the Madras Bar Association and various bar associations that this is an attempt to take away important powers of the High Court and use these tribunals as just as employment opportunities for retired civil servants. You have the National Company Law Tribunal, which has 62 members, of which 30 can be technically civil servants. Same thing in the National Tax Tribunal. So overall, the intention seems to be to keep on hacking away the powers of the High Court. You have taken away the tax, company law, intellectual property, step by step, debt recovery, and you keep on manning them with retired civil servants. So that's our basic objection. And you mentioned the Iradi Committee. Incidentally, I appeared before the Iradi Committee, and the proposal of NCLT was never raised before the Iradi Committee. It was just introduced by a side wind at the end of the report, unfortunately.
So what you're saying, Mr. Datar, is that even if these design defects, as listed by you in your petition, are fixed by the Companies Act or by the Ministry for Corporate Affairs, you would still be opposed to and you would continue to agitate against the National Company Law Tribunal and Appellate Tribunal?
We will, yes, about the Company Tribunal, about the Taxation Tribunal, we'll continue to agitate to the best of our ability. Because we want to ensure that these, first of all, these powers should be restored back to the High Court. But now, because of the earlier view saying that tribunal is valid, that may not be possible. But we'll have to aim to the maximum extent possible to ensure that the tribunal is independent and does not become one more department of the Ministry of Company Affairs, which today it will be. It has got no independence whatsoever.
All right, so I'm going to come back to why you want to reopen a case that's already been decided in some sense by the Supreme Court. But first, before that, Bharat Vasani, would you agree at least with the point being made in the petition that there are design departures from what has been laid down by the Supreme Court, and hence those have to be fixed? Why would the Ministry for Corporate Affairs depart from what the Supreme Court has clearly laid down?
I think substantially they have complied with it. There are certain areas where they have departed from the R. Gandhi
These are
judgment.
material areas, right? For
Yeah.
instance, the selection committee, the way the Supreme Court designed it, the final say would be, or the casting vote would be with the Supreme Court Chief Justice. The way it's been designed in the Companies Act, there are 3 positions on that selection committee which are non-judicial. So the bureaucracy and the government have the final say.
I think the Supreme Court judgment in R. Gandhi's case should be followed in letter and spirit. I think the para 56 of the judgment, which kind of spells out the guiding principles on which the tribunal needs to be constituted, should be followed in letter and spirit. I do observe that there are deviations.
Right.
Nobody can deny that, and I suppose the Ministry of Corporate Affairs is best advised that as it is, they may have to introduce Companies Amendment Bill sooner or later to fix some other issues.
Yes.
They can also fix the issues with regard to the composition of the National Company Law Tribunal and the Appellate Tribunal, and bring it completely in line with, because we have to respect the decision of the Constitution Bench of the Supreme Court, which has dealt with this issue not very far. It's only in 2010. So I suppose that those can be fixed. But we need to have, as far as the debate on the issue of whether we need to have tribunals for dealing with this matter, I have a slightly different view.
All right, so let's get right into that. Mr. Datar, you said you will continue to agitate even if the design defects are fixed. My question to you is, this matter has been decided in 2010. So why is
Yes.
the Madras Bar Association attempting to reopen a case that is closed now?
You see, the point is, we first said that the Company Law Tribunal should not be formed because company disputes are primarily the realm of the judiciary. And it will be interesting to note, we mentioned this to the Supreme Court, we gave several foreign judgments which have not been unfortunately considered. And we told the Supreme Court that, look, if you talk of a company tribunal, in no Commonwealth country is there a company tribunal. In England there are more than 100 tribunals, 110 tribunals, and there is no company law tribunal. Why? Because these disputes are primarily in the realm of the judiciary and not the executive. Because you can have an income tax tribunal, you can have a telecom tribunal, these are all technical tribunals, but you can't have a company tribunal which is dealing with civil disputes. And we are worried about a much larger danger. You see, now you got the National Tax Tribunal which is
Mr.
pending before the
Datar, forgive
Constitution
me
Bench.
for interrupting you here, but sir, the Supreme Court did decide in 2010 that the Parliament has the right and the competency to institute these tribunals. That decision's been made by a 5-member constitutional bench. Why would you seek to question that again?
Yes, because the point is, as far as the thing is concerned, we still feel that the R. Gandhi case has not dealt with the issue of separation of judicial powers adequately. There are several foreign judgments which touch upon the role of the separation of powers which are not being dealt with. And in our opinion, it does require reconsideration. We have put our case. I mean, if the Supreme Court agrees to it, they'll have to examine where is the Lakshman Rekha to be drawn between what can be referred to a tribunal and what cannot be referred to a tribunal. For example, can you refer check bouncing cases to a quasi-criminal tribunal? You cannot. So those lines have to be clearly drawn.
I think in my view, the May 2010 judgment of the Supreme Court is the kind of final decision on the NCLT part.
Yes.
If it is to be reconsidered, as Mr. Datar is arguing on the issue that the doctrine of separation of powers, which has been the kind of a basic structure of our constitution, is laid down in Keshavanandan Bharti and several other cases thereafter, then it has to be referred to even a larger bench.
So bigger than 5.
Bigger than 5. I don't think that we should go down that path, in the sense that, the fact remains that the high courts are overburdened. We have a huge backlog of cases in our judiciary. More than 3 crore cases are pending in different high courts and other judicial forums. The question is that, are we reacting because some of the tribunals we did not do it well in terms of the setting up of the tribunal or manning them properly or providing them with the infrastructure? If we can do it better with NCLT, there is a case, I would say that even company law is becoming increasingly very specialized. This tribunal will be dealing with cases of mergers and demergers and complex cases, of corporate restructuring.
Right.
I have come across instances in my career where I found that barring few high courts which are used to company law matters, because there are a number of company matters which are coming up, there are several high courts in the country which do not have much of experience in dealing with corporate law matters, and particularly complex corporate law matters. Now, if you happen to be representing with a company or dealing with a company which has a registered office in not so familiar jurisdictions, I have
So
come
not
across,
Bombay or not Delhi, let's say.
some of those
something like that.
major high courts which are very familiar with the company jurisprudence. I have come
I
across
think you can include Chennai also.
All right.
Yes.
Not Bombay, not Delhi, not Chennai. Yes, sure.
Yes, sir. But then I've come across instances where it's difficult to explain the nuances of the Companies Act, mergers and demergers and PE multiples. There's a famous case of the Hindustan Lever Termco where some of those issues, it was difficult even for the sophisticated High Court benches also to understand the nuances. Now, if you create a specialized tribunal, I don't see any logical flow in that argument that you cannot have a National Company Law Tribunal, because the company law has become specialized subject now, and there are so many finer aspects this tribunal will be required to deal with. All we need to do is that, since we are now consolidating various fragmented jurisdictions of Company Law Board, BIFR, High Court, and also conferring certain new powers like dealing with class action lawsuits and minority rights and other stuff, we need to ensure that the tribunal is absolutely properly manned by persons of unimpeachable integrity and of extremely high technical competence. If you do that, I tell you, success or failure of the Companies Act 2013 will be entirely determined by how is NCLT constituted and how they function. First of all, it will be much shorter because the time frames are laid down that within 3 months they have to dispose of the matters, and there's a 60 days windows to appeal to the Supreme Court. So
you'll get everything: expertise, familiarity, speed,
everything. And and I have seen that with other tribunals also now. With if you go in TD side, you go directly to Supreme Court. The period for final disposal of a litigation has been significantly brought down by removing the High Courts from in between.